And today I'm going to talk to you about the basics of employment law in Utah. First, let me put in a plug. Here's why you want to practice employment law on behalf of employees. First of all, almost everybody that you know in your adult world works somewhere. So they understand employment law inherently, and it affects them. And so every time you're working on an employment law case, you're doing something important for somebody to help them continue or get employment. Second of all, the issues involved in employment law are varied. And you're looking at mostly federal law, as you'll understand by the end of my talk. And you're talking about laws where there's conflicting circuits. You're talking about U.S. Supreme Court cases in this ever-evolving world of employment law. And if you practice for employees, on the other side of your cases are some of the best lawyers in the state who practice for employers. So it's never a dull moment. Now, what I'm going to talk to you about today is very quickly all the different types of claims that you may see if you practice in this area and how to identify them. So here's the first thing you need to know. You need to understand the concept of at-will employment. So private sector employees, people who work for private employers, not the government, are typically subject to at-will employment. They can be fired for a good reason, for a bad reason, or for absolutely no reason at all. So if that's the case, then most terminations that you see, the employer is going to be fine just walking into an employee's office and telling them you're fired. But there are a few exceptions. First of all, an employee who is fired for no good reason can get unemployment benefits after their termination. The only way an employer can prevent an employee from getting employment benefits after they've been fired is if they have a good reason for their termination. And they have to prove that good reason in an unemployment hearing. Second, a private sector employee who is fired for following the public policy of the state has a claim of wrongful termination. And it's called, the full name is wrongful termination in violation of public policy. And what that means is if somebody does something that they're allowed to do, for example, file for workers' compensation benefits, and they are fired for exercising that right, then they may have a wrongful termination in violation of public policy against their employer. Also, private sector employees have to be fired for a good reason when they are in a labor union and they are covered under a collective bargaining agreement. Typically, those labor union employees have the right to be fired only for good reason, and if they're not fired for good reason, then they're allowed to challenge those terminations under the collective bargaining agreement, typically in a grievance procedure. Now, oftentimes people confuse two terms. They confuse at-will employment with right to work. And what at-will employment is, you now fully understand. But right to work means that if you are in a right to work state and there's a labor union that you do not want to join that's in your workplace, you don't have to join that labor union, and you can continue to work in that workplace. In states that are not right to work, you have to join the labor union that is in your workplace and represents you as part of the collective bargaining unit. The right to work moniker is a misnomer, as you can tell. The idea that you would have to, that the issue of labor union membership may or may not have anything to do with the right to work, and certainly it doesn't have anything to do with the concept of at-will employment. Every state in the union is an at-will employment state except for the state of Montana, which requires that private sector employees be fired only for a good reason. Now let's talk a little bit about government employees. Public sector employees different from private sector employees, have property interests in their continued employment, which means they can be only fired for a good reason. And if they are not fired for a good reason, like labor unions under collective bargaining agreements, government employees are entitled to due process in a post-termination posture. They're entitled to challenge that termination and make sure that the employer has to prove that they had a good reason for the termination. Every tribunal is different. Different governmental entities, school districts, counties, cities, the state itself have different rules. They have different policies that govern these tribunals, and in each case, you should pull up those rules. They're usually online, and you can read about the hearing process so that if you represent somebody who's a governmental employee and they're challenging their termination, you're following the rules. Additionally, government employees, this is akin to the private sector wrongful termination and violation of public policy. On the government side, we have something called the whistleblower law. It's the Utah Public Employee Protection Act, Utah Public Employee Protection Act. And what that does is when a government employee reports wrongdoing, and that is waste in government, fraud in government, the governmental entity violating the law in some way, and then afterwards is harassed, demoted, or fired as a result of that report, they may have a whistleblower claim under Utah statutory law. So the biggest issue we see is the issues of discrimination and harassment typically brought under federal statutes. There is a Utah statutory law that prevents discrimination and harassment in the workplace. However, it's not a law under which you can sue in court. So we typically bring these cases under federal statutes like Title VII of the Civil Rights Act of 1964, the Age Discrimination and Employment Act, and the Americans with Disabilities Act. Now, the problem that you often have is people come to you and they say, I was treated different than my coworker. And then when you probe that difference, you find out that the coworker is the boss's next door neighbor or niece or something that is not protected. So the key for discrimination cases is that the differential treatment has to be because of age, gender, which also includes pregnancy, race, national origin, religion, or disability. And those are called protected classes. And the discrimination has to be based on the person's protected class. And it can't be for some non-protected class, such as the way the person dresses, how tall they are. Those kinds of things are not protected classes. So the discrimination has to lead to some sort of discrete employment action. A failure to hire, a failure to promote, a failure to pay equally for the same job, or being terminated. And this, remember, has to be because of the person's membership in this protected class: age, gender, race, national origin, religion, disability, and those have to be part of the mix. And you have to try to figure out if that's part of the mix, oftentimes when the employer doesn't tell the person that that's why they're being treated differently. These are cases of circumstantial evidence where you're looking for comparators, how people in the non-protected class are treated compared to the people in the protected class. So when we're talking about protected classes, oftentimes we get the question of whether or not sexual orientation, gender identity, can be protected. So in other words, are gay people protected under the non-discrimination laws? Not only are they not right now protected under federal law, they are not protected under state law either. There have been a couple of bills up at the legislature in successive legislative sessions attempting to add sexual orientation and gender identity to the list of protected classes. It has not been done yet. However, there are certain governmental jurisdictions that have put into their local ordinances a way to bring discrimination cases against employers that discriminate based on sexual orientation. For example, in Salt Lake City, there's a way to sue an employer for violating discrimination law, their discrimination ordinance based on gender identity and sexual orientation. And also you should look for, in larger companies, oftentimes their handbooks include something that talks about anti-discrimination for based on sexual orientation. And in that case, there are times when you can bring a breach of contract based on the handbook against the employer. It's typically multi-state employers, larger employers, but you should look for that also. Then we have the issue of harassment. Now, typically, people understand very well the issue of sexual harassment in the workplace. Going back to the Anita Hill, Clarence Thomas hearings way back when in the 90s. But now what we have is the issue of harassment based on any protected class. Harassment based on disability. You can have harassment based on race. You can have harassment based on national origin. And the difference between straight up discrimination and harassment is an ongoing pattern of hostility, or in other words, I like to think of it as a bunch of small cuts that when added up together are one illegal job action that the employer is taking, as opposed to one discrete act that typically leads to some sort of financial impact on the client. The whole pattern of behavior is one case of hostile work environment. You often hear people say hostile work environment. Hostile work environment is a synonym for harassment on the job. Then we have a case after harassment and discrimination, also involved in all of these cases under these federal statutes, you can bring a case for retaliation. And oftentimes, retaliation is the easiest case to prove, not the underlying discrimination or the underlying harassment. Because what the person has to show is they either oppose discriminatory treatment of themselves or others in the workplace, or they participated in reporting discrimination or harassment, or they participated in an investigation. And in short order, some job action was taken against them, or they were harassed because of their report. So that is the issue of retaliation. All of these federal statutes have anti-retaliation provisions in them, and in order to prove retaliation, your client needs to just have had a good faith belief that what they were reporting or the investigation they were participating in had something to do with harassment or discrimination on the job. Disability discrimination under the ADA, the Americans with Disabilities Act, also involves something called a right to reasonable accommodation. And what reasonable accommodation is if a person is a disabled person, so they have a health condition that substantially they have a condition which substantially limits their ability to perform a major life function, and those functions are the basic functions of life: standing, sitting, reaching, reading, thinking. All of those things are major life functions. And if their disability inhibits their ability to do that, then they are a disabled person under the ADA, and they're entitled to a reasonable accommodation. Each person with a disability is not entitled to be fired as long as they can do their job with or without a reasonable accommodation. For example, you could look at our slide, and if the person needs to be able to keyboard, but they have some sort of carpal tunnel syndrome that prevents them from actually keying well, and there's a voice recognition software that they could be provided, that will be seen as a reasonable accommodation so long as it's not too pricey. And the employer can use expense as a reason why they don't want to provide a specific accommodation. But every employer has to enter into what the ADA calls is the interactive process to see if they can reach a reasonable accommodation to let the employee do their job. Now, the things to remember about these discrimination, harassment, retaliation, accommodation claims is that you have to exhaust your administrative remedies, your client's administrative remedies, before filing in court. And what that means is you have to file with one of two administrative agencies. You either file in Utah at the Utah Anti-Discrimination and Labor Division, you file at the Utah Anti-Discrimination and Labor Division, or you file with the federal agency that investigates discrimination, the United States Equal Employment Opportunity Commission, USEEOC. You don't have to file with both. You can file with either, and you only have 300 days to do it. The UALD, the Utah agency, will investigate claims that you file within 180 days of the employment act, negative employment action. And then if you file 181 days or longer, up to 300 days, it will be kicked over to the US EEOC. So you have to let the EEOC or the UALD do an investigation, or you need to at least leave it there for 6 months. But then you can pull it, you ask for a right to sue letter, and that's when you can go to court. Typically, these cases are filed in federal court. However, you can file them in state court, courts of general jurisdiction. Employers will tend to remove them. The other thing that you have to keep in mind when you file these claims is they only apply to employers that have 15 or more employees. So you can't, surprisingly, under Utah law, file even a sexual harassment complaint against an employer that has, say, 5, 6, 7, 8, 9, 10, up to 14 employees. They are immune from sexual harassment suits. There might be other claims that you can bring, but you cannot bring a discrimination claim. Also, Title VII and many of these discrimination acts have damages caps. Now, hard damages are not going to be capped, meaning fixed economic losses can be whatever they are. However, there are damage caps based on the number of employees the employer has for both distress damages, emotional distress damages, and also for punitive damages, and it's a joint cap. But on the positive side, attorney's fees are statutory, and they are awarded when you're successful in these cases. So the employer has to pay my attorney's fees when I win these cases, and that is something that doesn't exist in a lot of statutes and in a lot of cases, so be mindful of that. Now let's move on to the topic of family and medical leave. An employee is allowed to take family and medical leave for a serious medical condition of the employee or their immediate family members. They're also entitled to this leave for the birth or adoption of a child. Family medical leave only applies to even bigger employers. They have to have 50 employees within 75 miles, and generally the employee has to work for a year for the employer before they're entitled to take this leave. But if it's a bigger employer and the employee has worked for a year, then the employee can get up to 12 weeks of unpaid leave, though the employer may have a policy which is legitimate under the law to make the employees first take all of their paid leave before they move into unpaid status. An employer is entitled to get medical certification from the employee. It is required, and the leave needs to be approved by the employer. After the leave, however, the employee must be returned to the same or a comparable job. We see claims under family medical leave when the employer either fails to inform the employee that they're entitled to take this type of leave, or they retaliate, again, retaliation is important, against the employee for taking the leave, or the employer makes getting the leave so onerous that they interfere with the employee's right to take the leave. Another claim that we sometimes see or oftentimes look for is a claim under the Fair Labor Standards Act, the FLSA. The Fair Labor Standards Act is, again, a federal claim. It requires that employees be paid a minimum wage, which is sometimes important for tipped employees. And even more importantly, and the thing that we see the most of, is employers denying overtime pay to employees who are not exempt. And that means that in any week, any work week, an employee that works over 40 hours must be paid time and a half for overtime. But beware of the exemptions. You need to pull up the Fair Labor Standards Act, I do it every time, and read the exemption for every employee I think may have been cheated out of overtime. There are vast numbers of exemptions, and it's impossible to memorize them all, so look them up. Overtime violations are something that are prevalent in the Utah workplace, in the American workplace. Employers often feel that employees won't know that they're entitled to overtime, and when you talk to somebody about any other employment claim, you should ask them the basic questions about the type of work they do so you can decide whether or not they're exempt. If they are not exempt under the Fair Labor Standards Act, you should make sure that they are being paid overtime. Those types of claims are, I would say, the easier of the claims to prove in employment law. They are oftentimes multi-plaintiff cases. There is a provision under the Fair Labor Standards Act that allows you to bring a collective action, which is different than a class action. Under Rule 23 of the Federal Rules of Civil Procedure, you can join a bunch of claims and you can go back 2 or 3 years in getting that overtime for folks. So in addition to those federal claims, there's a few other state law claims that I just want to mention. First of all, there are many issues of non-compete agreements that are brought in state court. In that case, you would, if you represented an employee, you would typically be the defendant in a case like that. The employee would be sued for violating a non-compete agreement, a signed agreement that they previously entered into, saying after they worked for an employer, they won't go work for a competitor. They don't have to be fired to have that ban apply to them. They could leave voluntarily, and oftentimes those are provisions that are added to contracts and apply broadly, even though they are only supposed to apply to people who have special, unique, and extraordinary skills. However, I've seen non-competes applied to salespeople. I've had non-competes applied to janitorial staff, and all of those would be reasons to go into the court and tell them the non-compete should not apply. Also, I've seen employers try to overreach where the non-compete agreements extend for years on end. In Utah, the courts have said that typically employment agreements that have non-competes the non-compete provisions cannot extend more than 2 years. So those are cases that you may see. Another thing that we see under Utah law is claims under the Utah Payment of Wages Act. Again, a statutory provision, this time in Utah code, and the claims under that act arise when employers fail to pay employees. And typically, it's a failure to pay outright. It's not, oftentimes employers in at-will employment situations will change the amount of the compensation with or without adequate notice, but the act doesn't protect employees against that. It just protects the employee from not being paid at all for the work that they do. Okay, and then also the FLSA might kick in to make sure that they're paid at least minimum wage. So that act protects employees from being stiffed for the work that they do. So thanks for listening. It's not to say that this kind of law is easy to understand or straightforward in any way, and identifying claims for Utah employees is sometimes a really fun treasure hunt through statutes, both federal and state. But I would encourage you to do this kind of law, to take a case, to explore this area of law, because it is definitely rewarding to work for working people. Thanks.